the two judgments that we rely on are Botswana is the one, and that's a Gauteng South judgment, and the other is Hydrotech Systems Pty Limited. That's a decision of this court. And essentially, the point that they make is that a party is entitled in their replying affidavits to take up an issue that was less substantially pleaded in the founding affidavit once they see that the issue becomes a contentious one. It's impossible for an applicant to be prescient as to what is or isn't going to be taken up. There's just one specific aspect that is important in relation to the issue of the specialist report. If your ladyship can just take a look at paragraphs 91 and 92 at page 55 of volume 1. There's an attempt to strike out a wide swath of matter relating to whether Mr. Arendse was an expert and whether his report was a report as envisaged and required we submit by Heritage Western Cape. And then there's a strikeout application on the basis that we never made that part of our case. If we look at paragraph 91, about halfway down, it says, the Heritage Western Cape's overriding concern was that the second HIA had not accounted for the intangible significance of the site flowing from its historical associations, and that the assessment was consequently flawed. The interim comment concluded with the recommendation that a specialist consultant with expertise in intangible heritage should be engaged to provide a supplementary report. And then the important paragraph is 92, and the word that it begins with. It says, instead, the LPT caused a supplementary report to be submitted in December 2019, which was prepared by the same authors as the second HIA and essentially re-argued its conclusions. A copy of relevant sections of the supplementary report are attached. The supplementary report also included, and so it goes on. Essentially what happens is they say that they dispute that. They put up a curriculum vitae of Mr. Arendse, and it's quite clear from their response to those particular two paragraphs that they have understood the allegation that's made. That's why they attach his curriculum vitae. That's why his curriculum vitae has those top two lines. And with respect, on the basis of the two judgments that I've referred to, we're then into a legitimate debate on those two judgments in the replying affidavit. Given that the First Nations parties approached by the heritage consultants during the public consultation process elected not to submit comments on the draft when it was circulated, it was accepted that the HIA could be improved in that respect. As a consequence and in an abundance of caution, the LLPT implemented the recommendation of Heritage Western Cape in its interim comments and duly appointed a specialist consultant with expertise in intangible heritage. So they can see the debate is on as far as that issue is concerned. And then it's legitimate to put up an affidavit by Prince Solani, which then takes the issue further. In, I think it was the high-tech judgment, they took an auditor who hadn't, a forensic auditor who hadn't given any initial affidavit, and she looked at the financial statements put up in the answering affidavits and analyzed them and produced a report. And they said, that's okay. We say this falls under the same category, and for that reason should not be struck. So, lady, we submit that, save in respect to those paragraphs, the strikeout application should be dismissed. But I'm not sure what your position is in relation to timing. That was the response I prepared to the first and to the fourth and fifth respondents. The cities I only heard this morning, and so I can do my best to try and whip through as much of that as I can. I'm not sure if your ladyship would like me to proceed.
The court cannot stop you. The court will give you your full hearing. Yeah?
As the court pleases, my lady. I'll try and keep it brief. One of the submissions my learned friend made is that the decision makers considered and decided that those buildings will not harm intangible heritage. We say that's irrelevant, that that decision-making process took place for purposes of assessing irreparable harm and the balance of convenience. With respect, that's your ladyship's assessment in these proceedings. The notion that we said that the only thing we want is a right to a judicial review is not correct. I subsequently elaborated upon that substantially. We've dealt with the golf course on the site. We've dealt with the issue, your ladyship has raised the issue of whether the applicants took any steps to protect, and I've answered that. In relation to the issue of there being consultation on the planning of the buildings that are allowed to go ahead with respect, that obviously isn't a solution from the perspective of the applicants. We would respectfully support the proposition that was put to your ladyship that there's a difficulty with trying to attach an economic value to intangible and tangible heritage resources. They're essentially priceless. We've dealt with the issue of the pending review proceedings and whether or not those will be a source of delay. There was a submission that we have the advantage here that the developer has said that they are proceeding at their own, has accepted they are proceeding at their own risk, and therefore that they can be ordered to knock it down. We've debated that, my lady. That's not in the real world. In the real world, those buildings, once they're up, are going nowhere. There's a suggestion or an argument that the shifting nature of the case and it has collapsed. Yes, we acknowledged and readily accepted that there was a difficulty with the refinement of the review grounds. We've made our position clear as far as that is concerned. We don't think that that is such an unusual circumstance. One had exactly the same circumstance that, perhaps exactly as overstating it. One had a similar circumstance in the Shell case. We think worse, in fact, because there it seemed crucial to the survival of or prevention of the collapse of that particular case that they had to get a judicial review going in respect of the exploration right, which they hadn't done at all. There wasn't even a review. And that didn't deter the court, as the court gave them the assurance that they would do that. And important, and it's a crucial fact from a number of these perspectives, including the perspective around costs, my lady, is we're sitting here in a situation where it's not an ordinary proceeding where the next, it's the end of the case once the replying affidavits are filed. There are going to be opportunities for us to file another affidavit, to amend. Always happens in a review. Invariably, you change your review grounds, supplement them, change them, chop and change, amend your notice of motion. And the fact that you can amend your notice of motion shows the kind of leeway that the rules envisage in terms of refining your case and taking it forward. And we've indicated the basis on which we say we're likely to reformulate the case against the city. In relation to the eighth respondent, there's a suggestion that the arrangement that is in place in respect of the development of the site for First Nations, as far as First Nations is concerned, is one that gives effect to the right of return. In fact, the right of return is something which is increasingly the subject matter of international law, and it's well recognized in international law that the right of return means what it says. You go back and you go and live at the place where you were before you were dispossessed of your land. So by no stretch of the imagination is the current arrangement the restoration of a right of return. So in conclusion, we say that the strikeout stands to be dismissed, save in respect of those paragraphs. If the strikeouts are granted, we submit it should be that it is only for the purpose of the interim
Sorry,
interdict.
can you just start again? The strikeout application should
Be dismissed, save in respect of the paragraphs that I have conceded. Even if the strikeout applications were all to be granted, the applicants we submit have made out a case for the relief sought on the papers as they would then stand. In all the circumstances, it is submitted that the applicants have made out a case for the grant of the relief sought in Part A of the notice of motion. Applicant does not persist in the relief sought in paragraph 2.2 of Part A of the notice of motion. The applicants were forced by the conduct of the first respondent to bring the Part A relief. They have been supported in their prima facie unlawful conduct and in resisting
The applicants abandoned the relief sought in paragraph 2.2.
2.2, yes, Maggie. I think it was linked to the provisional protection issue.
Yes.
We say that they've been supported in their developers have been supported in their prima facie unlawful conduct and in resisting the interim interdict proceedings by the remaining respondents. In the circumstances, the respondents should all be ordered to pay the applicant's costs. Such costs to include the costs of two counsel jointly and severally, the one paying the other to be allowed, and it would be consistent with the relevant provisions of NEMA, and in terms of the relevant provisions of NEMA, I should say. We submit that the cost orders sought by two governments and a wealthy developer against a civic association and a group of vulnerable First Nation people would ruin them financially. It would in effect destroy them as organizations. Although not entirely on all fours with this matter, we submit that your ladyship's judgment in mineral sands stands in the way of a costs order of that nature being granted, although the circumstances were slightly different. The effect of a cost order that is in conflict with BioWatch may well force the applicants to proceed with an appeal, which is not a scenario that I think is necessarily in anybody's interests if they were minded on that in those circumstances not to do so. The basis for the bypassing of BioWatch was primarily, as I understood my learned friend's argument, pointed to on the basis that they weren't asserting a constitutional right. That argument has been dealt with, and if your ladyship is with us on the argument that they're asserting a constitutional right, there certainly hasn't been anything like the kind of conduct that is envisaged as depriving one of the protection of an order in BioWatch. In addition, they have the protection of the relevant, I haven't immediately got a chart, I think it's section 33.1 or 2 of NEMA. The applicants have done a real service for society. The heritage consultants acknowledged that almost all comments on the development were in opposition to it. They were willing to come forward and do something about it and effectively represent both civil society and those Khoi groups who do not go along with the development. They have paid a heavy price. Mr. Jenkins had to take out a protection order as a result of his involvement in these proceedings. That's at page 731 of the record, at paragraph 53 of his affidavit. He and the second applicant have been most inappropriately attacked and vilified in the affidavit filed by the eighth respondent in the ways that echo those of the Orense report. We submit that was a complete abuse of the legal privilege that attaches to court documents and is a factor to be taken strongly into account in not making any cost order against them in the event that the court is against us. As the Constitutional Court recognized in BioWatch, it is groups such as the applicants that breathe life into the Constitution. Snuff them out, as the respondents clearly wish to do, and you snuff the life out of the Constitution itself. Lady, we would like to put up the analysis that I was reading from the laptop of who the other source within the record of the list of people we say weren't consulted, yes, on a simple,
The court reconsidered its position. The court will just determine the matter on the papers. I am withdrawing my request for any additional notes in this matter. It may just set in motion something that the court did not. There may be unintended consequences should the court
This-
receive any note from anyone. So I'm withdrawing my request for any notes. The matter will be determined on the papers as it stands.
this is on the papers, lady,
As long as it's on the papers, you're welcome to.
as
Raise it.
the court pleases. Those are the submissions in reply on behalf of
What did
the
you refer
applicants.
to? Is there anything you wanted to refer the court to that's on the papers? What are you referring to? The list of the groups who,
Who are reflected in the appeal in relation to the provisional
Yes.
protection,
yes,
as the court pleases.
Thank you very
Thank you
much.
for bearing with me, milady, and going past time
yeah,
on
no
a Friday.
problem. Thank you very much to all the parties. Your heads are indeed very valuable in this matter. The court will need time to consider this matter. I will try to give priority to it. It is an urgent application. Judgment is then reserved. Thank you very much, everyone.